Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I am the Extension Legal Specialist here in the Department of Agricultural and Resource Economics at the University of Maryland. And today on the podcast, we're going to start two episodes featuring people from the Penn State Ag and Shale Law Center talking about various issues that they deal with. Our first episode will feature Brook Duer, who is there and does a lot on solar. So he and I will have a conversation sort of on some of the issues that are facing rural landowners and communities as we start looking at adding in larger solar operations into some of these areas. So turn it over to the recorded interview. Welcome back to the podcast, everybody. Today we have on Brook Duer, and I'm going to go ahead and just let Brook introduce himself to talk about what he does and who he is.
All right. Okay. Well, thanks, Paul. I'm Brook Duer. I'm an attorney up in Pennsylvania, and I have sort of a circuitous route as to how I got into agriculture as a sort of legal specialty. I graduated from law school way back in the Stone Ages, back in the early 90s, and actually 1989. And I went to Lancaster County, Pennsylvania, of all places, pretty randomly, really. I got an internship a clerkship for a judge. And I didn't know the town or anything, but I ended up landing in the leading agricultural state of Pennsylvania, really the center, the hub of agriculture, in the entire state and even, broader than Pennsylvania. It is really quite a center. And so you couldn't practice law there without being sort of involved in agriculture. You just learned everything. I have a funny story. When I was a law clerk for the judge in my very first couple of months, they grabbed me to go sit on an arbitration panel, which is Pennsylvania's version of small claims court. And what's the case? It's a Amish farmer whose tobacco got rejected by his contract buyer. And I forget which, cigarette or tobacco company it was, but they said it wasn't of the certain grade, and so they were downgrading his tobacco. And he was so mad that he just pulled the tobacco and did not sell it to them. And he actually had the tobacco bales in the courtroom and he's putting them up on the witness table. And I'm just sitting there like, wow, I was just completely floored by this. And you still to this day, you don't see Amish, plain sect is really the right word to say. You don't see plain sect people using this legal system as a plaintiff as much as you will see them otherwise engaged in other parts of the legal system. That's still a rarity that there was an Amishman who was a plaintiff because he ended up suing. And so anyway, so I was there. I did that for 18 years, and I was in private practice and did all kinds of things. I was doing insurance defense and then sort of a litigation specialty practice. And I knew some guys that were very, very into sort of a more rural practice. And one of the attorneys did 1031 exchanges, and they represented the Lancaster County Agricultural Preserve Board. And so they had a lot of connections and a lot of plain sect clientele. They had an office in Intercourse, Pennsylvania, the famous Intercourse. And so I went in with them for my final about 5 years. And then I was real good friends with some people in the governor's office, and some things, went around. And then eventually I was asked to become the chief counsel at the Pennsylvania Department of Agriculture. So I said, sure. I thought this is really interesting. So I left private practice, and, I was in my late 40s and, I'd been practicing like 20, years almost. And so then I worked there for about 12 years as I was chief counsel, and then during a Republican administration, I was just an assistant counsel in the office, and then a Democrat got elected governor again, and I became the chief counsel again. And so then I started talking to Penn State, and then I ended up here at the Penn State Ag Law Center. And I'm getting to that point where this will hopefully be my last enjoyable ride into the sunset. I really interesting dynamic because the Penn State, it used to be called the Ag Law Center, just straight up, and it was created by statute. But then what happened is, and this will cover sort of the background of what our center does. Then what happened is the state stopped funding it, so the mission morphed a little bit, and then it became the Center for Agricultural and Shale Law, because Pennsylvania sort of experienced this giant, shale gas boom, and I saw that from the Department of Ag side. I didn't see it from the other side. I was watching it all. And the funny part was I used to handle all of the funding, the grant funding that went from the state of Pennsylvania to the Ag Law Center at Penn State. So I was the other side of the grant agreement with Ross Pfeiffer, who's the director. Now Ross is my boss. And and I was the guy who would always sort of talk to Ross about, work plans and that sort of stuff under the grant, and now I'm on the other side doing the work under the grant. So the Penn State Ag Law Center, and I still call it that. I'm not that involved in the shale side, but the Ag Law side, we get grant from the state of Pennsylvania to operate this, and as well as having a grant from the National Ag Law Center, which is that National Ag Library from USDA money, and then we do some other grants here and there, and we're all part of the law school, which is a little different for some these kinds of programs. We're not part of Extension technically; we're part of Penn State's law school. And then that's kind of gives you access to some interesting resources. Plus, it gives us a little bit of autonomy that's nice, because we don't have to follow, I hate to say it, but we don't have to follow all the extension rules about certain things, like how to put on a webinar and who you got to use and all that kind of stuff. So that's kind of nice. So we do that same role that a lot of these land grant, legal centers do. As you know, Paul, we've worked together, and so we fill that role, do lots and lots of producer education, and also educator education, educating extension, and PA state government. They rely on us for things. One of our feature things is we do a weekly newsletter. We call it the Agricultural Law Weekly Review, and we really jam pack that full of all sorts of stuff. We do a podcast, and we just put up our new website, so we're very excited about that too. We're just trying to fill it full of all the things. Sometimes how it is, Paul. You have all these materials that stockpile over the years, and some of them kind of fall by the wayside, and then you got to brush them up and sort of freshen them up. And so we're still in the midst of sort of stocking that website full of all the old stuff.
Oh, good. I need to check out your new website. I didn't realize it had gone live yet, but you do a great weekly update on everything that needs to come out. I think it comes out Tuesdays.
Yeah, that's what I try to do, Tuesday mornings for the previous week. And I sort of took over that. That became my baby when I came here in the fall of 2019. And then, of course, like inside of 6 months of being here, the pandemic hit. So now I do work out of my home in Lancaster, back in Lancaster. Which is kind of nice. This working from home thing was nothing I ever bargained for, but it's kind of working. So yeah, I really try to jam pack that newsletter full of everything, and hopefully those who get it can appreciate it, and then that can spark the interest, and I'm not really a guy who has any ego issues with, like, I just put everything in there, and I'm not looking for, people want to use it, and whatever they do with it, that's fine. It's just a service for everybody. And we do the same thing on the shale side. We have a version like of the shale, and the industry in Pennsylvania in terms of the shale gas, end of things. We're a little bit more for pure landowner at this point. The industry itself is kind of less active, let's put it that way, than they were when they were staking out, all of the leasing and drilling the initial wells and everything. Now they're capped, and they're waiting for pipelines to get the gas out of here, basically, and waiting for the market to give them the kind of price that they want and that sort of thing. We still do that on the shale side too. We have a newsletter like that, and the pandemic has been interesting for us, because webinars became the standard now. So it's so much less capital intensive and risk free to do webinars, and you don't have to charge. It's not like you're renting a room, and it's nice to, it's easy. You can work on the fly and do a lot more and you still get your 30 or 50 people. I mean, it's really nice. We went over, we just did this, what we call the Penn State the Penn State Solar Law Symposium. And that was a 6-hour continuing legal education course that we had 104 people sign up, which was nice. That was sort of a breakthrough for us to get that kind of a crowd. Plus, we were charging for CLE credits, so we weren't sure if that was going to go over well and whether we were going to get good attendance, but we did. So, and tying into the solar thing, I mean, I do solar webinars for Penn State Extension, and they get hundreds. I mean, they'll get 200, 300 people for these, solar webinars that they do. And it seems to be, new people. There's always a few repeats, who clearly know what they're doing, but then there's tons of new people constantly. If Maryland's anything like, Pennsylvania, we're just, solar is just front and center everywhere. Everybody wants to talk about it.
I mean, yeah, that's the main thing right now that I end up dealing with the most, it seems like, with landowners. So, and that leads kind of into, we've both been working on solar leasing,
right,
and having to deal with this. So I thought it would be good, instead of having a conversation with myself,
yeah, right,
to
exactly,
have somebody else on to talk about it with.
Right.
So yeah, and you kind of hit up on the next question I had for you, which is kind of what's the climate like for solar in PA?
Yeah, and it's a little unique maybe than other states. We have the one thing that maybe some other states don't have, which is we have this residual out there from the shale gas boom that we went through, starting in about, 09 or so. And so the sort of the part of the infrastructure, so to speak, more like the human infrastructure, was already here. Landmen out in the countryside, dogging down, leads and looking at leasing properties. Used to be for gas. Now a lot of them are doing the solar leasing. So you had this already there. And now that can be a negative also, because while the shale gas industry did and still does, brought great income opportunities to parts of Pennsylvania where the shale gas existed and exists. But there's also a little bit of a bad taste in some quarters' mouth with things that went on, maybe environmental issues, or with fracking wastewater, and roads being torn up with heavy truck traffic, and perhaps there's a little bit of negativity that can come from being so quickly on the heels of the gas industry here in Pennsylvania. Now, I don't know if Maryland's, I didn't know how much shale gas you guys had.
We didn't have any. When what we ended up having right when I first got here 9 years ago was we had people had signed leases, and then fracking, there was a moratorium on fracking, and then.
Okay, so you had a moratorium.
Yeah, and the leases were in some cases not the greatest that they signed, so the moratorium was actually probably more beneficial.
Okay,
to landowners.
And the moratorium in New York, of course, changed everything too. It didn't, we did one thing, and New York, right over the border, did something completely different. So we have like two completely different environments heading into the solar leasing boom, so to speak. And of course, they have the similarities, the two industries, in terms of having these lease documents and then having the development proceed. Now in the solar, obviously, it's proceeding much more slowly because of the nature of it. It's that sort of institutes that same concept where the landowner wants to know about, well, like, how's the payday going to be? And so there's this intense attention or interest in the payday part of it, but in the gas side, the upfront paperwork part of it is kind of steeped in oil and gas law, and you have all these issues that are steeped in subsurface mineral and gas rights, and what does that give this, in terms of surface disturbance? And there's a little bit of stuff that is not in the contract, so to speak. It's common law that carries along with it, and property law. Well, in the solar side, you don't really have that. You just have a straight old lease. This is just a lease. So when people would say like, oh, I need an attorney who's, experienced in solar leasing. And it's like, what you need is just a commercial attorney who understands a lease, whether it's a lease because it's a ground lease. This is like a parking lot or a shopping mall or, the old ground lease concept, a 99-year ground lease or whatever. It's the same thing.
I was going to say too, or a cell phone tower.
Yeah, cell phone towers. It's funny because I'm so old. I remember when cell towers were brand new and everybody would, and I used to go run around to townships all around Lancaster County and do cell tower hearings. And that's when the guy from the cell tower, from the cellular company, they would bring a cell phone with them to the hearing, and everyone would oogle and ogle over it like, oh my God, look at that. It's a phone. You can take it in your car. And, it was this big hunking thing that was heavy. But I remember those days when you were just, out there in these townships trying to educate them about, what a cell tower is. And it's not going to, it's not going to cause cancer, and your cows aren't going to get tumors from it. And, so.
Yeah.
Anyway.
It's fairly, yeah. And you bring up a good point. I mean, if we're looking at an oil and gas lease, my guess is the standard oil and gas lease in Pennsylvania, where oil and gas production started in the U.S.
Yes,
was
right.
2 pages, 2 to 3 pages at the most.
Right. Mm-hmm. Yeah, right.
We're dealing with
these 50, 60, 70, 80 page documents.
That may have multiple pages that say the same thing.
Yes,
and
right.
That say the same thing.
Yeah.
We don't want to go to court. We don't have common law on our side.
And I always tell people these documents that they're using out there were just, somebody hit the print button on some, giant commercial lease in some high rise in Manhattan or something. And, some attorney took a little bit of time to try to customize it to the solar industry, but not a lot of time. And so these documents are just like these recycled commercial leasing documents. And someday, hopefully, we will see them boiled down. But right now, like you say, they say the same thing in like 7 different places. And it drives these, and of course the landowners have these big thick stack of papers when they, get the landman stops by, and, they're just like, well, they just want to know what the price is. They just want to know what the dollars are. But then the scary thought is that what we have now, particularly, here in PA, because I think people jumped and thought somehow it's like gas moved so quickly that people thought they were going to miss out or something. So I think a lot of people thought they were going to miss out on solar too. So, they signed things. There's people out there now who signed things and never had a lawyer look at it. I mean, that's just so scary when you look at some, because you notice the thing about these documents a lot of times too is they're sloppy. They don't have things that they should have that are pretty obvious, or they have something in there that is like, well, of course this can't be here, or this doesn't make any sense. And, they're just not well crafted. Now, I guess, I don't know if you guys, are you seeing, Paul, lately I've been seeing a little bit of improvement on at least streamlining so that there might be the option and the lease itself are all in the same document, which can have its good sides or its bad sides. Yeah. But at least they're starting to get to that point.
I've been seeing that more and more where everything's kind of streamlined.
Yeah.
And I think that brings us to my next question. As we're talking about these leases, is sort of, we're really dealing with like 3 documents in one, aren't we? We're dealing with an option, a lease, and then how we're going to clean the site up at the end.
Yeah. And right. And I always, my biggest, and that's, I usually try to explain to them, and you'll see this other thing that's maybe 1 or 2 pages, like it's their little offer sheet where they give you this little piece of paper that tells you some prices. And I always tell people, the reason they're doing that is because they just want the confidentiality part in there, because they want to convince you that you can't go to your neighbor and tell them what price they offered you, and what lease rate they offered you. And but then, so I always tell them that that's what that little document's for. But then, of course, you see them starting to slip in the agreements sometimes now, these clauses that say, well, if I offer your neighbor X rate, then I'll offer that to you too. And you see a little bit of that going on as these things get evolved. But right, the three, or at least the two, the two document thing causes so much confusion, particularly because it's so repetitive. Most of the same stuff in the option agreement as in the lease agreement. Now, my biggest warning, that I like to stress, and I'm sure you do it and everybody does it, is I always explain, okay, this is what a unilateral option means. It means they can say no and back out after they sign the option agreement, but you can't. And you just have to drill that into their heads that once you've signed that option agreement with that lease attached, or if it's one of these where it's all together, that's it. You cannot walk away. And you won't get, theoretically at least, any more shots at negotiating anything.
Even with the option at the end to extend it past a 25 to 30-year period, it's like, nope, it's on them. It's not on you. You can't say, get off my property.
Yeah. And so you always have to remind yourself to drill that one home, when you're giving a webinar or educating people, because it's like, they get it. This is it. Once you've signed this thing, they can say no and say, okay, thanks. We took a look at your property. We decided not to go forward, but you don't have that choice.
We had oil and gas leases that had those options in it. After 5 years, nope, you don't have a say and get to renegotiate.
Yeah.
We can option it and pay you the same amount regardless of what it. So in the end, it worked out well for some of these landowners that didn't have anything reviewed, but solar is a different beast. So looking at solar, what are key terms that you tell people besides?
Well, I have sort of a list. The one is the unilateral option. That's obviously something I like to make sure I drill home. Another one that I like to drill home is this idea that, okay, leasing means exclusive possession to the tenant, which means there's going to be a fence around this and you're done. Your days of walking on that property are over. It is their exclusive possession. So don't think that you're going to be able to do, if you need any rights to do anything in there, you got to make sure you're very explicit about it. Because sometimes people don't get that, it doesn't sink in. Now, the subordination requirements for outstanding liens and things, and like a principal mortgage, for example, I always make sure I talk about that, intensely, because I think that's one of the most misunderstood things. And I don't think the industry even has uniform practices in that regard. But I always tell people, your first mortgage, if you have a mortgage on this land, you better go talk to them now before you even sign this thing, because, your tenant is going to demand from them a subordination. Of course, you got to explain what a subordination is, but your tenant is going to request a subordination from your mortgage holder. So your bank is now involved in this thing, and this has to happen. Now, I've heard a little bit, and I don't know, I'd be interested to know what your war stories are. I've heard that some of the developers are negotiating over the subordination requirements and settling for something more, or I should say, something less than a full subordination like we would think of it. But I'm not sure what that would consist of exactly.
Yeah, I'm not sure on that. And I haven't heard of that here, mainly because as we've done some research, we're seeing specifically in one area of the state where they're looking at leasing, and in other areas they come in and buy the property outright.
Yeah.
And it's a lot, and it's specifically in a few areas where they will just buy you out because it's just in the long run easier.
And
it's cheaper, I think, too, in the long run, just to buy the property.
In the long run. And that's an interesting point, which is, after a few months of working in this area, maybe I got into it maybe not quite 2 years ago, starting to collect the leases and everything. I sort of thinking to myself, well, for these developers, this is complicated, this leasing thing with why aren't they just buying, or why aren't they clearly putting right in there? And maybe it's because they're strategically, they don't want to scare anybody yet, is option to buy, after X number of years. Because I can imagine how this industry is going to go is once they get their hook up to the grid and the power's flowing and the money's flowing and things are working and and everything's fine, then you just buy the property. I mean, at that point, you're secure. You have your income stream. You've done what you need to do. I mean, it's like the option, or excuse me, the lease agreement is only because you don't know whether you're going to get the whole thing done yet. So you have to have an option, and then you should make it an option to lease, because it's there's a lot of pieces that have to fall into place here, and the shakeout at the beginning of it all. You don't want to be so capital intensive that you're buying all this acreage. You just lease it, and it's low overhead, so you can flip the company. So people have to realize that these developers, this whole I don't want to call it an artifice. This entire model that they're using is simply because they have to get their project funded. And funding a lease is so much easier than funding the purchase of the property. And so, but once they get the power flowing, then they should just buy the property. And that would make so much more sense. It's like, okay, we're stable now. Let's buy these 150 acres or whatever it might be, and proceed. And I assume that's really where we're going. 5-10 years from now, we won't even recognize this industry, because a lot of these leases, I assume, will be bought out.
That's what I've assumed too. I've just assumed that in the long run, what you get, panels put on a property, you can go change technology at any point. Yeah. You now have property tied up, and you have an option that only you can decide to option it or not.
Yes.
And so it just makes no sense to let property up. I'm like, once this property is leased, it's solar forever. Right. It's a conservation easement in reverse in a way.
Yeah. And right. And one of the other, we have a guy who teaches at Dickinson Law School, which is Penn State's sort of sister law school. There's 2 law schools at Penn State. And he does the sort of municipal stuff. He worked in government on energy project financing and stuff. Anyway, he taught me that lesson of like, once they get the connection to the internet in place, that's the gold. That's where the value is here. So at that point, this idea of focusing in on decommissioning and, what happens if they abandon and leave all these panels there? No one's going to do that. Mm-hmm. Once the power is flowing, this is a license, don't say license to print money, but this is that's where the gold is that now you have the connection to the grid, and you can, send the power in, and that's worth so much to them that, that's no one's ever going to abandon one of these, or, it's just not going to happen. Batteries, it's always going to,
batteries are going to get better. We're going to be able to store this power.
Right.
We're not going to need a coal-fired power plant at some point.
Right. It's always going to have value. This connection to the internet has so much intrinsic value. The internet, to the grid, has so much intrinsic value that no one's going to abandon these projects in some way and leave a mess behind. Which then gets to the whole bonding thing, which is a whole other mess. That people are obsessed with this bonding idea, and I think there's so much twisted information out there about that particular issue. Yeah. Let me get to you had asked about key terms, subordination, and also the other things that I like to talk about are like, okay, what other commitments have you made legally to other parties? Like, for example, in Pennsylvania, we have our preferential tax assessment program for ag lands. We call it clean and green, is what it's called here. And so it has if you change the use to, a grid scale solar generation facility, then you're going to suffer 7 years worth of rollback taxes. You got to pay the tax benefit for the last 7 years back to the government. And so generally, I just start out by telling people, okay, if you're in the clean and green program, which in Pennsylvania has just astronomical enrollment numbers, then, it's not a use permitted. So you're going to have a rollback. So most of the leases very clearly say that the developer will pay that. So that's not the issue, but the issue is just when the funny part is, let's say they're leasing 150 of your 300 acres, you can re-enroll, all 300 acres have to come out, and they get kicked out, and you owe the back taxes on all 300 acres, then you can re-enroll the 150 that are not being devoted to the solar. So that's a little quirk that we have in Pennsylvania that, you have to sort of explain to people. And then you have this, the conservation requirements for any enrollment that you might have done, with NRCS. if you're in CRP programs or anything else, you're going to have conflicts here that this is not permitted, and you're going to have to figure out what the economic impacts are. If, can you even negotiate your way out of that? Which I don't know. Have you any good war stories on, CRP programs or anything? My understanding is NRCS is just saying no, and the contract is the contract, and that's it.
The main ones I know about are with property that was sold for other stuff where people didn't realize it was in a state conservation program or CRP because the deed was filed in the wrong county, and then they had to pay back a lot of the cost. Yes. The new owner paid back a lot of cost share. Not the old owner, but
thank goodness in these circumstances that the solar developers are sophisticated enough to understand what they're getting into, and they have that due diligence period where they can figure it all out, because a lot of times the landowners aren't, quite grasping those bigger picture issues, which it's one of the things I always say, goes along with stressing the key terms. I always use this analogy. I always say, you are now all of a sudden, Mr. Landowner, a sophisticated commercial landlord. You have entered the rarefied air of, sophisticated commercial landlords. You don't know this industry. You don't understand all the things that are involved. So you got to be ready to be in that role and take this very seriously. It's not like some farmer who's going to be, planting corn or beans, on your 150 acres. This is a sophisticated relationship where not only do you have impacts on other liens and other easements and other things that your land may be tied up with in the chain of title, but you have this long-term relationship you have to maintain theoretically with a very large company that is in the, they may have borrowed, $100 million to put in the panels on this property, depending on how big it is. So you're playing with some big players here. They may flip their companies fairly often. You're going to be dealing with a new owner every couple years, perhaps. And you got to deal with the property tax impact too, which is now in Pennsylvania, the property taxing entity is the county, and the county, they collect it even for the school districts. So our schools are all paid for out of property taxes. And so the counties, doing the assessment, they aren't going to send two bills. That's not going to happen unless we have a change in law in Pennsylvania. So you're going to get one property tax bill, and you're going to have to split it with this company who, Lord knows where they're going to be headquartered by the time you're trying to send the bill to them. So, you got to be ready for some particularly, complicated communications. You got to make sure you keep your insurance certificates and get them updated every year, so that the coverage is in place, and just all of that stuff that you're going to have to deal with. And they have the right to appeal the tax assessment in your name, so you're going to get potentially dragged through some tax assessment appeals, which are not pleasant sometimes. You don't make friends with the county when you do stuff like that. And so and we have found, at least I don't know if you have found this in Maryland, but we have found that the tax assessment community, in terms of the county assessors, is what we have in Pennsylvania. There's county assessors, and they're the ones that handle it all. They set the values. They're not necessarily completely schooled and ready for this. Exactly how it's going to, how, you got the income method, or, the cost of replacement method. And I'm sure that, they're going to use the income method to figure out, what the assessment, how much the assessment should go up. These structures are clearly accessible, in my opinion. I don't think they qualify in Pennsylvania as, like, if you have like equipment, that's one thing, but these are improvements to real estate. These are going to be permanent structures that are that receive, an increase in your property tax bill and your reassessment under Pennsylvania's system. So, you're going to have this whopping giant tax bill now, and I don't know if, maybe the assessors community is ready. All they have to do is, get a couple under their belt, and they're fine, with the values that they're going to be setting. But have you had any discussions in Maryland with anybody about that, or tried any education or anything?
Not yet. We're working on it. It's something that's been in the pipeline to kind of do and kind of get a better sense of, because that's my guess is no one's going to know how to do any of this, and we're going to have the same problems where.
Yes, I saw a publication from, I think it was Virginia, that was within the last year or so, that was an economic impact report on solar leasing, economic impact projections. And a key part of it, of course, was how much new property tax, is this going to generate. So that looked like to be one of the only places that I've seen that issue sort of delved into. And that kind of fascinates me, because when I was at the Department of Agriculture in Pennsylvania, we were very intricately involved in Pennsylvania's preferential tax assessment program, the Clean and Green program, because the way it's set up, the Department of Ag, Bureau of Farmland Preservation is supposed to provide guidance to the county assessors all over the state on how to administer this Clean and Green program. So we were intimately involved in it, although we did not have authority in terms of telling them what to do. We were supposed to promote uniformity from assessor to assessor, in other words, from county to a county. And we made, this is another thing, we may not see uniformity from assessment jurisdiction to assessment jurisdiction. And, I tried, what I'd love to get to the point with some of the people in the industry is read their eyes, like, are you people going to litigate these tax assessments into the ground? Or are you going to take your lumps and just pay these bills and be glad that you're making the money that you're making? Because if they start to fight every tax assessment tooth and nail, boy, this industry will get a black eye real quick. And there's other things, that can give them black eyes, but that's certainly one of them. So that's, and now here's my last thing. You were talking about key terms. I think one of the key terms that is just this idea that, and it's not necessarily a term, but it's an impact of entering into the lease and everything, is think about the subsequent owners. And I'm a little fuzzy on how the future is going to look when you have 300-acre farm, 125 of it is leased for solar production, but it's still a unified parcel that's going to be sold together. What impact does that really have on the fair market value? Yes, it's an income stream, but it's, it can have negatives too. Mm-hmm. I mean, that can be a negative. And then you get to the point of, should you be subdividing it so that the solar leased area is subdivided off so that the rest of the acreage is freely alienable, so to speak, and that it's not impacted? So you got that looming, in the background if the developer doesn't buy you out at some point.
Because I would say the biggest thing I do there is I always talk to people, you got to have everybody in the room, kids, and everybody's going to take this property over, because the impact's not going to be on you.
Yes.
It's going to be on your kids. And if they want to take this farm over, you've just cut it in half, or it may all have panels on it, depending on what it is. And is that what they want?
Right. Yes. And yeah, exactly. And now we get to the, is that what these heirs want, so to speak? But then you start to get to the whole neighborhood, the community concerns. And, I think you asked me about Pennsylvania's, environment. I'll tell you one aspect of Pennsylvania's environment right now with solar leasing is the natural gas industry does not like this development. They are fighting it tooth and nail. And they have really taken the banner of, we're losing prime farmland. So the gas industry is the one who's now championing this idea, and many other people, who are legitimately concerned for farmland, preservation and conservation, that, we're losing prime farmland. And I put that in air quotes because that can be true, or that may not be true. And one of the things that happened in Pennsylvania that didn't get us off on a good foot, which is probably even a bigger black eye that this industry could get, besides, fighting all the tax assessments, is Penn State did a project up here where the equivalent of 25% of the entire electrical use of Penn State University and all of its branch campuses is going to be generated by 3 solar projects, all in the south central part of the state. So 25% of Penn State's electrical use will be provided by solar in the next couple of years. Great. I mean, it's a very forward-thinking thing that, is hopefully an accelerator for the industry. Now, the Commonwealth of Pennsylvania, through the executive branch, unilaterally, because they're in charge of procuring electricity for the government, they signed a deal for 50% of the entire Commonwealth of Pennsylvania's electrical usage will be provided by solar facilities in 7 different counties in Pennsylvania in the coming years. And so very forward thinking in that regard. Now, here's the black eye, however, or the potential black eye. It appears, yes, to the Penn State for sure on those 3 sites, perhaps even all 7 Commonwealth of Pennsylvania government sites are going to be land that in fact was actively being farmed at the time that, it was put under lease. So I think the industry would have been better served had it stepped back for a minute and picked and tried to identify locations that were old, mine lands, some type of other brownfield or something else other than active farmland. Because there is nothing that gets a Pennsylvania government official more glory than talking about farmland preservation. And there's nothing that gets them more worked up than talking about the loss of farmland. And, we are a big state. We have tons of acreage. And, we have parts of the state where these projects are never going to fly, for example, Lancaster County, because, the farmland, the prices are just so high here. And it's just the richest farmland with the Susquehanna coming down through there, and everybody knows the story. So, but I think this thing got a little bit off on the wrong foot with using active farmland. And I just was looking at the statistics in preparation for this call. To produce 10% of Pennsylvania's electricity by solar means would require 80,000 acres. We have 200 and some thousand, old, mine lands, that are abandoned mine, mostly strip mining. That land is out there. And yes, it costs more to develop this land. It's not flat and nice, but I think this industry would have gotten off on a better foot had it done that, because this has given people, the not in my backyard people and the gas industry and others, it's given them a foothold to really cry foul. And it's concerned the legitimate conservation, community that, wait, well, what are we doing again here? Is this just another competing interest for farmland that is, nullifying the millions that we've spent on farmland preservation? So that's a little bit of the Pennsylvania environment here.
Yeah, and I'll say I've looked, because I've been going through our State Utility Commission looking at where the filings are at to get an idea where stuff's active at. And we have at least 2 projects that I know are, just based on the name of the project, they're abandoned mines.
Yeah, okay.
They're reclamated mines that need
people would love. That's great. People would love that up here if that was going on, but we've seen none of that yet. It's because of these 2 big signature projects out in front. And of course, those projects, just so people understand who are listening, those will remain, the power will of course be generated by the developer. These are not projects where Penn State is owning the generation facilities or the Commonwealth. It's just, they're just buying the power. So, these are developers who have made these decisions as to where to site things. Not the state of, not Penn State University. But yeah, this loss of farmland issue, I think, is going to loom very, very large for us up here. Now, you mentioned something right there that was really key for the unique nature of Pennsylvania too, which is the Public Utility Commission. Our Public Utility Commission has no involvement in siting or approval of the sites. The Pennsylvania state government, and I believe that the legal reason for that, threading it all the way back through the needle, so to speak, is that this is not a sale of power to a consumer. This is generating power to sell to the grid. This is a transaction that is outside the PUC's jurisdiction. So the developers in Pennsylvania have no oversight for site selection and very little else from the state government. The only oversight they get from the state government is the general basic, erosion and sedimentation control, and wetlands, and all the normal things that would apply whether you're building a parking garage or a solar, generation facility. So they go to FERC, and they, and the interconnect system and the PJM. They get their approvals to generate and contribute to the grid, but they don't go to the Pennsylvania Utility Commission and get any approvals. So we don't have any way in Pennsylvania to track where the projects are, except looking at the FERC, or actually the PJM, the interconnect website. So that's a weird absence, and void here that our state legislature has not seen fit to address. And this is all happening so quickly. And our legislature is a bit bogged down with, partisan, divisions. And so I don't think they're going to address it. So Wild West is almost, being permitted to happen in this area right now. So the little townships are the ones. This is kind of a quirky thing, but get this. When a project is signed, and the developer decides to go forward with it, they file their things with FERC and the PJM. And okay, so those entities know what's going on. No other Pennsylvania state government entity knows what's going on until the proposal is filed at the local municipal level, at the township level, to get zoning approval. That's the first time that any governmental entity that is under the state of Pennsylvania's rubric hears about the project going forward. I mean, That's the first official filing, relating to the project. And so these little township supervisors, they're getting inundated with this, and they're going to be the battleground. All the protesters are going to come to the township office, and so they're not ready for this. I mean, it's
anything utility scale here goes to the Public Service Commission. You have to get a certificate of public necessity and convenience through the utility process, same utility process, a coal-fired power plant or nuclear or anything would go through, and you've got to follow all this. But the counties have to be actively involved in the process, and we're still trying to figure out what actively involved in the process means.
Yeah, right.
We have court cases where the county was not actively involved, and it went through the whole process, and the Court of Special Appeals said, oh no, you have to give them an opportunity to be involved. Well, they had every opportunity to be involved, but they did not exercise that opportunity. They didn't have zoning requirements at that point. So they couldn't be involved. So so I will.
It's funny. One more thing I was going to mention, the bonding thing. You have that dichotomy between, is bonding just a matter of for the decommissioning, which probably is never going to happen, but is the bonding a private matter between the landowner and the developer only, or what is the government's interest in the bond? And in Pennsylvania, that's the only area where we've seen much legislative interest. There was a bill introduced to require bonds, but the weird part is it's bonds payable to the state government, and the state government doesn't have any obligations with regard to remediating these sites. They're not, unless you had some kind of environmental contamination from the panels or something. I mean, so it's kind of a misdirected, thing that the legislature put forth about bonding. It's like, I always question the basic concept of, well, what's the government's interest in a bond in this situation? If you build a parking garage, nobody says, on a leased land, nobody says, oh, you got to post a bond to make sure you take that parking lot down when the lease is up. I mean, that's not, anything that goes on. And, so why is that going on in this circumstance, at least in Pennsylvania, where we don't have any state regulation of the siting itself? And that's a weird quirk that we have here. Very strange.
Ours is all tied into the state process. There has to be a bond put in place. And I asked the landowners, like, you need to negotiate to make sure that whatever's included in that protects you, because
yes,
don't take the state at their word that this is going to get cleaned up. Yeah, don't trust anything, because we don't know who's going to be in charge if this thing does have to be decommissioned. Protect yourself.
Yeah, the bond needs to be payable to you, the landowner, and make sure that. And I see this. I've never seen this in a lease yet, which is absolutely essential. That a bond must be reissued, of course, every single time the property changes hands, or every time the lease is assigned to a new owner. Because a bond, there's no insurance company in the world that isn't going to take advantage of the fact that that name on the bond is the wrong company. That was the last guy that owned it.
Yeah.
So that's when people talk about, well, who sets the price, the amount of the bond, and how are you going to do that? Well, what's going to dictate a lot of that is the fact that the company, the project's going to change hands a bunch of times, and every single time there's got to be a new bond issued. So I think your agreement really needs to say something like every 5 years, and upon every assignment of this lease to somebody new, a new bond has to be issued payable to landowner with the present value of remediation.
Yeah.
And that hopefully takes care of it. But I've yet to see anyone actually acknowledge that they need to have a new bond every time there's a change of hands.
No, that's a good point. So yeah. Any last thoughts on solar?
I guess I feel like we're in an industry that's out. The cart is a little bit out in front of the horse, in the sense that government hasn't fully appreciated all of its interests that it may wish to have addressed in this boom, in this coming avalanche or flood or whatever you want to call it. And I hate to see the mess that it might be created when the industry is 7-10 years down the road. And then all of a sudden, government starts jumping in to impose things that they didn't impose at the outset. So that part of it scares me.
Yeah.
That we're not responding in a timely way, and this industry is really leaping forward. And so that kind of scares me. I think that's my final thought.
All right. Well, thank you today for coming on the podcast.
Thanks, Paul. Thanks for having me. It's always fun.
Thank you for listening to this episode. If you have any questions, my contact, Brook's contact, is down in the show notes. A link to their center is also there, and some of the work they're doing as well. So thank you again for listening, and enjoy the rest of your day.